Okay, so good day, class. So today we're going to briefly study PD 957 in the context of its application in law. So, what are the cases wherein PD 957 have been uh, evoked or applied? So, okay, so I think this was a case posted by Batas Natin. So, it's PD 957, the effect of the absence of certificate of registration or license to sell by the HLRB. So what happens last if there is no certificate of registration or license to sell? So does it mean that the contract will become null and void if these documents are missing? Especially that these documents are requirements in PD 957. So let's examine this example cited. So in Spouses Quotient versus Sanctal Realty and Development in 2007. So there was a sale of a realty, but there was a contention that the sale is void for the lack of prior certificate of registration and license to sell by the HLRB. So is the contention correct and why? So will the contract become void since there is no certificate of registration license to sell? So let's read the explanation by law. So the answer is no. So PD 957 is a law that seeks to regulate the sale of subdivision lots and condominiums. So in view of the increasing number of incidents wherein real estate owners, subdivision owners, developers, operators, and our sellers have reneged on their representations obligations to prove and maintain properly the basic requirements and amenities as well as reports of alarming magnitude of swindling and fraudulent manipulations perpetrated by unscrupulous subdivision and condominium sellers and operators. As such, PD 957 requires the registration not just of the developers, sellers, brokers, and owners of the project, but also of the project itself. So, upon the registration of the project, a license to sell must be obtained prior to the sale of the subdivision lots or condominium units therein. So, I think it was stated in our previous lessons in PD 957 that when you register your project, you must have a license to sell, which will be obtained by the sale of the subdivision lots. So, the law also provides for the suspension and revocation of registration license in certain instances, as well as the procedure to be observed in the event thereof. Finally, the law provides for administrative fines and penalties in case of violation or non-compliance with the provisions. So, a review of the relevant provisions of PD 957 reveals that while the law penalizes the selling of subdivision lots and condominium units without issuance of a certificate of registration to sell by HORB, it does not provide that the absence thereof will automatically render a contract validly entered void. So, so it does not mean, class, that since there was no certificate of registration and license to sell issued by the HLURB, that the contract entered will become uh, void. Okay. So the penalty imposed by the decree is the general penalty provided for the violation of any of these provisions. It is well settled in this jurisdiction that the clear language of the law shall prevail. So the principle particularly enjoins strict compliance with provisions of law, which are penal in nature, and when a penalty is provided for the violation thereof. With regard to PD 957, nothing therein provides for the nullification of the contract to sell in the event that the seller, at the time the contract was entered into, did not possess a certificate of registration and license to sell. So it only means, class, that once, as long as the contract, the elements of a valid contract could be found, which is entered by both parties, it will not be become null simply because there was no certificate of registration and license to sell secured first by the developer. So, absent any specific sanction pertaining to the violation of the question provisions, sections 4 and 5, the general penalties provided in the law shall be applied. The general penalties for the violation of any provisions of PD 957 are provided in sections 38 and 39. As can clearly be seen in the aforequoted provisions, the same do not include the nullification of contracts that are otherwise validly entered. Okay? So the requirements of section 4 and 5 of PD 957 do not go into the validity of the contract such that the absence thereof would automatically render the contract null and void. It is rather more of administrative convenience in order to allow for a more effective regulation of the industry. While it is the intent of the provision section 5 of PD 957 to prevent the cases of swindling and fraudulent manipulations perpetrated by unscrupulous subdivision, condominium, seller, and operators, and to ensure that penalties be imposed on fraudulent practices and manipulations committed in connection thereof, such does not obtain in this case, as it is undisputed that the title to the subject property has been available for more than a year, and the Eagle Ridge project was almost 100% completed before spouses Scotian decided to have the contract declared void to seek a refund of their own down payment. So, according here, class, the project was already 100% completed before a case was filed to seek for a refund for their down payment. So, contrary to the spouses' bare allegation of bad faith on the part of the private respondents, the Court of Appeals found that at the time the contract to sell was executed, the applications for the certification and the license was already pending with the HLURB but were only issued several months thereafter. So it was found that okay, during the time that the contract to sell was executed, there was already application for the certification and the license to sell at the HLURB, though it was still pending. Okay. More importantly, when the spouses received notice of availability of the title to the subject property, the private respondents had long been issued the certificate and license. Okay. It was in fact the spouses who, instead of paying the balance as required in the contract, sought to renegotiate the same and falling therein sought to nullify the contract a year and a half after the notice that the title of the subject property, free from any liens and encumbrance, was already available for delivery. Okay? So here, it's reiterated again that one of the purposes of PD 957 is to discourage and prevent unscrupulous owners, developers, agents, and sellers from reneging on their obligations and representations to the detriment of innocent purchasers. So the law mandates HLURB to closely regulate, supervise, and monitor the real estate industry, particularly residential developments such as subdivision and condominium projects. To this end, PD 957 provides for issuance, suspension, and revocation, even the outright denial of registration and license to developers, agents, and the project itself, as well as penalties for the non-compliance with the requirements provided herein. It does not, however, provide for the nullification of contract due to the lack of registration license at the moment of execution, which in this case was thereafter undisputedly issued by HLURB. As correctly averred by respondent Alsons, the requirement for the registration and the license is primarily directed at preventing fraudulent schemes from being perpetuated on the public who have to seek their own abode. So, no fraud has been alleged, much less proven, by spouses in the present case. So, why class? Why is it like that? If you read it, if you read again the case, you can see that while there was no contract or license to sell at the beginning, it was already pending at the HLURB. And the developer delivered on its promise to finish the project. So the lack of certificate and registration doubt more will penalized under the law. Okay, so the lack of certification of certificate and registration without more, it is penalized under law, is not in itself sufficient to render a contract void. Okay? So it does not make the contract void, so it is still valid. So such a deficiency, however, together with other relevant factors, may be duly considered and nullify a contract should the circumstances demand. Okay? Now, then let's read again another case wherein what's the effect of failure to develop the subdivision within 1 year from the issuance of license. Okay, so in Zamora Realty Development Corporation versus the Office of the President in November 2006, there was a purchase of a subdivision property. The buyer notified the seller that it was suspending payment due to its failure to develop. Hence, the seller sued a notice of cancellation by notarial act. The buyer assailed the cancellation was affirmed up to the Supreme Court. Before the Supreme Court, it raised the issue of whether the buyer violated the contract when he suspended the payment of the monthly amortizations due to incomplete development. So, it was held no, there was no violation on the part of the buyer. So, under PD 957, the seller is obliged to develop the subdivision. Otherwise, the buyer has the right to suspend payment. And the only requirement under the law is to give due notice to the owner or developer of the buyer's intention to suspend payment. So what does it mean? Okay. So if the developer fails to deliver on its promises to complete the subdivision, then the buyer has the right to suspend payment. Okay? And with the only requirement that he has to give due notice to the owner or developer of his intention. Okay? So, the law does not specifically provide the form of notice to be given to the owner or developer. Considering the purpose of the law and the evil it sought to prevent, a verbal notice of the intention to suspend the remittance of payment is sufficient. Okay? So, under PD 957 class, if the developer fails to deliver on its promises, so the buyer has a right to suspend payment as long as he or she informs the developer or the seller. However, there is no specific form on how the notice should be delivered. So even if the buyer will just inform the seller verbally that he will defer payment, then it is still legal. Okay? So, we'll not go into the detail of this case since it has what you call this conjectures, which is only which is best left to the lawyers. Okay, so that's a lot of legal jargons. Okay, just to conclude class our lesson on PD 957. Okay, as architects class, our role in PD 957 is to ensure that the subdivision that we design or plan are in accordance to the provisions of that law. Okay? So, when client approaches you to make a design of a subdivision, so must first refer to uh, the different design standards set in PD 957 Then there's also another one, which is BP to 20 for the socialized aspect. Okay, so I think with this, we will close our lesson on PD 957. So I hope that you have gained a little bit of a legal viewpoint on its implications, not just in the practice of architecture, but also in the building industry and in the legal uh, context here in the Philippines. So, thank you, class. Good luck on your midterms and stay safe.